I'm meeting with Lisa Stockdale, the Director of the Office of Recovery Services here in Utah. And this is video 2 of 2 videos we've made, one of which is how to collect child support through ORS, the Office of Recovery Services. But now we're going to talk a little bit about what happens if you are the one who is being collected against by ORS, if you're the one that's paying child support through ORS, and what you can do to challenge that if you feel that the amount is wrong, or if you're not supposed to be paying at all, if you're saying, that's not my child, okay? So where would you like to begin with what somebody does? They've just received notice from ORS saying, we are opening a collection action, and we are collecting against you, and somebody says, let's start with this. Even though this doesn't happen as often, this is probably the simpler thing. Like, I'm not this child's parent. Okay, so what do we do first?
Well, they're going to need to talk to us about why they believe that they're not the child's parent. And we're going to have to go in and actually examine how this order was established and how it was determined that you were the parent. If it's actually already in order and it's been adjudicated that this is the parent, it's a little more difficult to challenge. So I don't want to get into too many details in here.
Because this is a short video.
This is a short video, but it's going to be very situationally specific, and it may not be able to be challenged. Most likely, if they think that there's a possibility of a challenge, it's going to happen in a court. So this is a very complicated process, and that's why it's very important that when these orders are being established, you take the time and really resolve that parentage issue right the first time.
So what you're saying is if somebody receives a letter in the mail from ORS that says, there has been a collection action opened through us administratively, and for those of you that aren't following exactly what we're talking about here, watch video number 1, because we talk about the various ways that you can establish an order. There's an administrative order, and there's a judicial order through the courts. There's 2 different, and there's some other things, but we're dealing with those 2. So I get a letter in the mail that says, Mr. Johnson, there is a woman out there who says that you have a child with her and that you need to pay for this child support. Well, that's bunk. That's not true. I don't even know who that person is, so I'm just going to ignore this.
Right. Any letter that you receive like that that's part of a legal process is going to give you very detailed instructions on how to respond and what your options are. Above
and what
all,
the time frames
and
are.
The time frames.
So
if
you ignore ORS, what's going to happen?
We're going to end up issuing a default order, because if you don't tell us that it's not right, we assume that you're okay with it if you don't contact us. And legally, we're allowed to do so, just so that there won't be a complete stall in the action in a process to establish.
I was given that opportunity, and I decided to not avail myself of it. That doesn't mean that nothing can happen. And I think that's true. A lot of people think, well, if I don't participate,
what can they do?
If I don't answer, you can't do anything without my permission. The answer is actually they can, because as you could imagine, there are a lot of people that simply don't want to pay child support, even if they should. And if all you could do to avoid that was just simply say, well, I won't respond, then you'd be able to afford that.
We would get nowhere.
Then you'd get nowhere. Okay. So now we're going to talk about a situation where child support has been established.
Yes.
And it doesn't really matter how, whether it was through court or whether it was done administratively through ORS. But you know what? And I've been paying, let's just use me hypothetically again. I've been paying, but I just lost my job through no fault of my own. And I am either looking for a job and it's taking longer than I expected, or I got a replacement job, but I only make 60% of what I used to make.
Okay.
What are my options now?
The best option you can go into is called a review and adjustment process. It allows the office to come in and look at everybody's income situations compared to when that order was originally established, to gather new documentation, to find out what the current situation is, to consider whether the current situation is temporary or not. So just a temporary job loss is probably not going to be enough to change.
Oh, you think I'm making this up? you think that I just don't want to pay child support? That's what it is, right?
You've heard all of this before.
So, and by the way, and we're not laughing at you, but we understand, because some people some people feel offended. They're like, oh, you think this is temporary? You think that I'm asking for an adjustment? I lost my job. It's been 6 months.
Right.
I thought I'd bounce back by now, but it's really hard to find a job in this area. So why do you have to find out if it's temporary?
Well, because you can, let's say somebody is incarcerated. Let's say they go to jail for one weekend. Yes, they were incarcerated, but but it was for one weekend, and is it really going to affect what they're able to earn? So we do have to it's almost like a management of resources. It takes a lot to go in and review an order and adjust that order. And often, from time to time, it takes court action to do that. So we have to be able to make sure that it's going to be a change that is lasting.
It's got to be worth your while.
Yes.
To put all the effort and the hours and the resources of your office
Right.
to find out if this really is something that's a permanent change, so that we do reduce or increase, and we'll talk about increasing later on.
Right.
Okay, so, all right, I've lost my job and I've come to ORS. What do you need me to do?
What we're going to ask you to do is to fill out a form or a written statement that says, yes, I do want you to do a review and adjustment on my child support case. We want to be clear that we've got clear permission to go in and examine your case. Then we're going to provide you with financial statements, asking you for documentation of your current financial situation. It's going to include questions about your bills. It's going to include questions about your income. It's going to include questions about any sort of nature of temporary change going up or down in your income. We want to get a good picture of what's going on with your income.
Okay, so I've given you the pink slip from my job where they said, it's just a reduction in force. I didn't get fired for stealing anything or something like that. Why do you need to look at my bills? I was told that child support is just based upon gross income and not based upon my expenses and things. Why do you need to see that? Number one, I don't see the point. Number two, maybe I feel like you're just kind of probing into my private life.
These are just the financial statements that are used across the board whenever we're analyzing income.
Okay.
Not just our office, but the courts as well.
Okay, so what you're saying is this is a form that is used by many people.
Yes.
We may or may not be looking at all the data that's in there.
Exactly.
Okay.
But it gives a complete picture of your financial situation.
Okay, so at what point can someone seek a modification? I mean, do I have to wait a certain amount of time? Do I have to leave the order in place for a certain amount of time before I can seek a modification where there's been a change in income or a change in needs or something like that?
No, actually a party can seek a modification or a review and adjustment of their order at any time. It's just that there's certain criteria that they're going to have to meet that's based on how old that order is.
So that depending upon how recent the order is, depends on what standard you apply?
Exactly.
And so what are those standards?
Well, the standards would be that it's based on a 3-year cycle. So let's talk about anything that's under 3 years old since that order was last looked at and established or perhaps adjusted previously. Okay. So it's been less than 3 years since that happened. We're not expecting a lot of changes in that time, but the law allows that if there's something dramatic that causes a 30% change in your income, either going up or down, that it might be worth looking at. So if you demonstrate that there's a 30% change in income going up or down, that's the first criteria you need to meet if the order is less than 3 years old.
So whether you're the payor or the payee, the one who pays or the one who receives, if your income goes up, your child support may go up.
It may.
If you're the one receiving and your child support, and your income goes up, your child support that you receive may go down somewhat because of your increase in your income as the recipient.
It really depends when you plug the incomes of both parents in and how they play off of each other for that total household
Not a
income.
guarantee, but it could affect. And then what we're saying here is that the payor, if the payor has an increase or decrease, the recipient can ask for a modification. The payor, him or herself, can also ask for a modification. And although this is very rare, if your income goes up and you feel, well, it just wouldn't be right for me to be paying this amount of child support when I should be paying more, you can ask for an adjustment.
Yeah, parents understand that this is still their child and this is the children they need to provide
Not
support
all parents,
for. Not all.
A very rare few, and then by the same token, somebody says, hey, I'm the one receiving child support, but I just got a new job or I just got a raise, and I need to notify the payor because that may affect child support. That person may be paying a little less.
Yes.
Okay, so you can do either one. All right, and within that 3-year period, what kind of change do we look at?
Well, once we pass that first criteria for that 30% change up or down in the income, then it's worth plugging it into the guidelines worksheets and seeing what happens. And at the bottom line, if it's a 15% change or more in the child support amount, which would be due, then it's appropriate to adjust that child support amount.
So if the increase or decrease of 30% doesn't result, when you plug the new numbers into the child support calculator, in a change to the child support amount of 15%, up or down?
Correct.
No change occurs?
No change occurs. It's close enough,
Okay,
basically.
but if there's a 15% change up or down, then you will make that adjustment?
Yes.
That doesn't mean it's only 15%. It's just 15% up or down will get a change. If it's 20% up or down, you'll
Correct.
get a change or anything like that. Okay. So what about a situation where we've now passed the 3-year mark? Because you mentioned this 3-year thing.
Right.
It's not a purely arbitrary number, but it's just, it could have been 2, it could have been 10.
Correct.
We just happen to have this 3-year mark.
Right.
That's a statute, that's a regulation.
Correct.
After 3 years, do we have a different set of criteria?
Yes, we do, because we expect that a child support order is going to last long term. We know that once you are ordered to pay support, you're going to be paying through that child's minority. So 18, graduation, or however it's set up in your order, that's a long time, and we expect incomes to change. So it's worth looking at it periodically, and like you said, they've set it at 3 years at this point. So at 3 years, it's a little easier to meet that standard, to decide it's appropriate to adjust. And
It's not the 30% standard?
No, we've eliminated the 30% standard.
Okay.
So we just take the income as it is for both parents, again, put it into the guidelines worksheet, and if that resulting child support order changes by 10%
Up
or
or down.
more, up or down, then it's appropriate to adjust that order to keep it the right size for that family.
Okay. Thank you very much. I appreciate that. So essentially, what we're saying is that the child's standard of living needs to reflect that of the parents. And if there's a change in a relatively short period of time from when the order was issued or last modified,
Correct.
we expect it to be a drastic change.
Yes.
30% or more.
Something we couldn't have foreseen or calculated at the time we set that.
We're not going to expect you to ride that out as the payor or the payee.
Correct.
But after 3 years, then we simply look at that and say, we'll look at the income as is, and if there's just a mere 10%,
Right.
If it's affected 10% up or down, we'll make that change.
It's important to keep the orders the right size for both parents' sake and for the children's sake.